This is the proper steps of a legal termination sponsored by the Workforce Development Board of Ventura County. My name is Stephanie Neely. I'm the marketing director here at CEA. Before we begin today's presentation, I'd like to go over a few housekeeping details with you. Your audio will be muted throughout the presentation, but we ask for your comments or technical issues in the chat box. If you have any questions about the content, you can type them into the question box. The question box has two speech bubbles at the bottom of your screen. We'll try to address those throughout the presentation. And if you have any additional questions, as always, please remember you have a HR hotline available Monday through Friday, 8 to 5. We're going to have that number up on the screen in just a moment. The slide handouts for this presentation were attached to the reminder email that was sent out this morning. I'll also pop them into the chat box in just a minute. If you need any additional help, please let me know in the chat box. I'll be there to help you out. This presentation will be recorded and will be available through Ventura County on their YouTube channel. You can also reach out to the work board directly, and we're going to have that contact information for you on the screen soon in just a moment. And one last thing, because your feedback is very important to us, please complete the survey at the end of the webinar. A QR code will pop up on your screen. Just snap a quick photo of it with your phone. It won't take you more than a minute to complete. I promise it's very short. We love getting your thoughts, your feedbacks, your suggestion, anything. We love improving our webinars and would love to hear what you think. Before we begin the presentation, we have Colleen Smith from the Workforce Development Board of Ventura County with a few words.
Thank you, Stephanie. Good morning, everyone. My name is Colleen Smith. I am a business solutions specialist with the Workforce Development Board of Ventura County. I wanted to quickly highlight some of our services, especially our hotline for employers. It's our no-cost complimentary HR hotline. You can call anytime, Monday through Friday, 8 to 5, and receive guidance on hiring, firing, termination, sick leave, employee handbooks, harassment, etc. So we really encourage you to take advantage of this wonderful service. I will also put my contact information in the chat as well. Like I said, I'm a business specialist, so we offer several no-cost services for our local employers here in Ventura County. So if anyone would like more information, please feel free to contact me. Like I said, I'll put my phone number and my email in the chat, and I look forward to hearing from you. And with that, I will send it back to Stephanie. Thank you so much.
Thank you so much, Colleen. You guys provide a lot of great services for your employers. It's fantastic. All right, now I'd like to introduce your speaker. We have HR business partner Joanna Luna here, and the wizard behind the curtain who's going to be answering your questions in the Q&A box, the box with the two speech bubbles at the bottom of your screen. We have Director of Human Resources Eli Nunez. Take it away, Joanna.
Well, good morning, everyone. Thanks for joining us here today. So let's start by learning a little bit more about who we are here at CEA. You do have a sponsored hotline through the Ventura County, and you can call in to speak to myself or another HRD about a variety of HR topics. And if you need additional HR support, you may want to consider a CEA membership. The additional support can include things such as training support, forms, toolkits. We have a variety of membership levels of support, including hands-on support through our HR Assist program. Now, what we are not is a legal firm, so we cannot offer legal advice. Please ensure to consult your own attorney if you have a matter of or question of legal significance. The presentation should not be relied upon as legal advice, and please consult with your attorney if something does come up of legal significance. As we talk, we will provide some guidance, but as you get through a certain point, we may recommend that you ask your attorney because it is in your best interest. So let's dive right in. What are we going to talk about today? What are our goals when we are terminating employees or coaching or discipline? We are going to talk a lot about documentation today. You have probably heard it. If you've been around HR or lawyers, they always say, document, 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 and yet people still don't document. So we're going to talk about how to document and how that can be your best friend, but it can also be your worst enemy if you're not doing it right. So we're going to tell you to document, but we're also going to show you how to document. So we'll talk about that. We are going to understand how coaching and discipline work together. These are two different things. Again, coaching is a skill. We have coaching sessions. We coach managers. We coach CEOs personally. We coach them. And here at CEA, we can also coach supervisors and managers and how to coach their team. Those are two different things or two different types of coaching, but they work hand in hand when it comes to discipline. So we're going to be discussing how to avoid legal problems when it's time to terminate, what plan you should have in place, and how to prepare for that. So let's start with how to develop proper documentation. What is the employee documentation? Well, each type of documentation will serve a different purpose. So we're not just talking about a written warning here. A document and the basic definition is a written and acknowledged document between the employer and the employee. And there's different types. So you have business values. These are things such as your mission statements, your open door policy, your work ethic. It's basically what you believe and how you are represented as a company. So those are, again, your business beliefs. They are typically in writing and typically included in your handbook. So check your handbook. And if you don't have a mission statement, it's probably a good idea to develop one. It's really important because we'll pinpoint to that from time to time, depending on what comes up in the employment cycle. We also have job expectations. This is where we clarify to employees what their job is. This can usually be found in the job postings or job descriptions that are presented to employees. And of course, these may not be all inclusive. That would be impossible. However, we should do our best to form a description of what the job is. Employees have rights, and those rights are placed in posters. CA, for example, has an all-in-one poster, and these posters should be in areas that are highly visible to employees, for example, a break room or somewhere where they gather. And legally, we are obligated to provide these notices and policies to employees. This will outline their rights on things such as leave rights, minimum wage, sick leave. All those things need to be documented and acknowledged. This is being done with their new hire paperwork, or at least we hope it is. So if you don't already have that as part of your onboarding process, make sure to review those notices and include them in there. And we have rules. These are policies that are written down so that we don't behave the way we would outside in the real world. We might behave different than we would at work, and that's because we have rules, we have policies. We can't say just anything in the workplace. We might be able to do that when, let's say, we're at the baseball field, right? But even then, I've seen those notices out there reminding parents that kids are around and cautioning them to have good behavior. Similarly, when employees are at work, we have written policies and we need to stick to them, and they give us a good reference as we move forward in these processes. The company may have conduct rules, professionalism rules, and then those that are discrimination and harassment rules. Those are there to protect the employees and the company. And then, of course, we have remedies. For example, an open door policy. What are the consequences? If there is a problem, who do I go to in the company? Who's going to help me? Who's going to protect me? All those things are important when you're dealing with the concern. And there should be a process that you follow. Advertise the open door policy. And of course, make sure that you're being consistent and that you stick to it. So why do we document? We reiterate, document, 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 but documentation doesn't necessarily have to be only when you're having a disciplinary meeting. Um, if we're having discussions, for example, we want to lay out the details of what we discuss with the employee, especially if we're doing something that will be adverse. So, for example, we are dealing with a policy violation and now we're having that conversation. So we want to make sure that we are addressing with the employee what we want to deal with, and we're documenting in a very factual way. If, for example, you have an employee who's worked with you for 20 years, You want history. You want to be able to look at that file and review the performance over time. And that can be done through performance evaluation, coaching, reviews. Um, that file will give you a chronological and precise description of the employee's action, the manager's actions. You'll be able to respond to, are we happy with them? Are we not happy with them? And what actually occurred during their employment cycle. It is going to provide evidence that's going to support management decision if they do take an unfavorable action. That could be discipline or termination. Now we have evidence of why we're doing that. Or it could be that we just need to give this person a raise or a promotion. Now we have a justification as to why this is a favorable action that is taking place. And then, of course, there's documentation to provide proof to justify those increases, to justify those decreases. For example, an employee might come to you and say, well, why didn't I receive a raise? Again, this is a good reason to have that documentation ready. I can't tell you how many times I've had employees who worked for a company for 10, 15 years, and they hardly have any documentation regarding their work history. And then a new supervisor or manager comes in and they inherit that employee. If there's no paper trail, there's nothing. You may have been in that situation, and that is a very, very difficult situation to walk into as a new manager. So how are we going to document this? So remember, the documentation is always discoverable, which means it can be looked upon in a court of law one day. So it can be found by an attorney, it can be discoverable. So what are you going to write? You want your best documentation out there for the world to read. Again, this may end up on a headline news if it's a horrible case or if it's a horrible loss. Of course, we never want that to happen, but you want to treat this documentation matter of fact as the way things happen. So in the event my documentation is out there being recorded or being reviewed by a jury, I want to make sure that it's done correctly. We want to be timely and writing the documentation immediately after conversation so that it's fresh in our minds. Uh, if we wait, the quality of our documentation is going to be affected. You're going to base it on memory, and for some of us, that's not always a good thing. And you'll want to document to be professional. You want it to be neat and organized. So find the tools to do that. For example, if you're a CEA member, we have access to coaching forms, written warning forms, and templates, and that keeps all of your documentation neat and organized and consistent because you're filling that same form for all employees, always including the same information. You want to write documentations as if you were talking about the history to a third party. So you're going to pretend that a third party is reading it. Again, it could be a judge, it could be a lawyer. You never know who's going to end up reading it. So keep it very specific and very factual and keep the emotions out of it. To avoid bad documentation, for example, if we're emotional, we may be writing in an emotional way, and that's going to show. And that could lead to someone thinking we have something out for this employee. So if you're being very opinionated about that employee, and maybe you have your own perspective and you can shed some light on that, it's probably better to leave that part out because you don't want it to appear that you're discriminating or that you're not being objective enough. So definitely avoid opinions. For example, Mike is sloppy, Alice is lazy, Tom is lying to me, Mark had an attitude problem. So you don't have to say those things. We just have to state the facts of why, in your opinion, Mike is sloppy. For example, Mike did not wear his proper uniform. He wore it unbuttoned. Alice is lazy. You don't have to say that. You can simply say, Alice did not finish her work. She was supposed to complete 10 widgets and she only did 5. Tom is lying to me. My statement might seem factual. Tom is lying to me. Again, it appears to be very factual, but you can say something to the effect of, Tom stated X when we checked the cameras. We actually found out that why it had happened. You want to be very factual. And as you get the idea here, avoid labeling. You don't want to label someone irresponsible or not being a team player. Just be factual and avoid trying to interpret the reason for the employee's behavior. This might happen a lot when we say something like, well, Marcia might not actually like the assignment, or Paula appears to be in over her head. Again, that's not necessary. Just state the facts. Minimize the use of descriptive words such as adjectives or adverbs. Look through your documentation once you're done. Take those out of it. You don't need them. And again, it should be factual. It should be fair, legal, objective, and definitely keep that consistency from one documentation to the other. So what are you going to document? What do you have to write down? Do you have to write down everything? Well, I know nowadays it may seem like we should write everything down, but no, not really. You want to write down anything that is important enough for you to feel like if this continues to happen or if that continues to happen, sometimes as managers, we want to be nice and we let things go. Then what happens 6 months down the road, it creeps up again. And now you're thinking, gosh, I really should have documented that. So please document it. Again, if it feels important enough to have that thought, then it's important enough to document that. So proper documentation will describe the policy or the issue or the concern that you discuss. It's going to include the dates. Those are very important. And a lot of the times we leave the dates out. If you're following a template, that's going to force you to include those dates. So again, find that proper form, those documents that are going to help you keep everything neat, clean, and organized. If you have a coaching with them, when did that occur? And then you want to state the impact of the employee's behavior. Because they were late for the fifth time, we had to call in extra people. Or maybe the orders didn't go out on time because they were late. Again, very factual about the impact the employee's behavior is having. And then you want to state the meeting outcome and next steps. So we're going to include what is going to happen next, what are the consequences, and then always include a follow-up meeting to check for those outcomes. We're not just going to leave them hanging, or we're just writing that so we can fire them in the next 30 days. We really should have a follow-up and see how um, did they respond to this? Are we being realistic about those next steps? A lot of the times, we can read through that. If you're really documenting to fire them, you want to be careful with that. Again, you want to make sure that it doesn't look like you're moving towards that, but that you're being factual. So that you want to try and coach them, have a follow-up meeting, and then again, be realistic about the outcome and what is to happen next. So here are 3 steps that supervisors should follow. So step 1, you want to again have a well-documented practice and engage with the employee. You want to be that manager that has dialogue and promotes that open door policy. I promise you it's going to benefit you in the long run. So be known as that manager that employees will talk to, and once they do, they know that you're going to document, they know that you're going to review, you're going to follow up, and you're not just going to sweep it under the rug. Be that manager that employees can count on when something needs to be done. Step 2, you want to be consistent. Be consistent in documenting, coaching, and your disciplinary actions. Don't play favorites or even give the appearance of playing favorites, and only discipline those that are critically uh, in violation. For example, a person is late every day, but now I'm overlooking the person who might be late maybe once a week. We need to be consistent, and you want to address the policy with both. It may be that maybe one only warrants a verbal warning and maybe the other one a written warning, but maybe we're not quite there. Whatever the level may be, you just need to be consistent. Inconsistencies when applying the policy, those will get us in trouble. And now people may find that we could be discriminatory in doing so. So keep that consistency moving forward and apply the policy across the board. And step three, be aware that coaching and disciplinary action protects everyone's right. Sometimes, again, we're just being nice by not documenting, but that is the wrong mentality to have. We're really there to protect the company when we're addressing these issues with the employees, but we're also protecting the employees' rights because they have a right to be warned. You are giving them time to improve. And again, once you do that, the ball is in their court. If we have a problem or an issue, you've told them about it. And now here you go. The ball's on your court, it's on your side. So let's talk about coaching. Coaching is a real skill. And if it's not done right, it can really harm the employer relationship. But again, when it's done right, it can be very effective. So coaching is going to support your counselings and your corrective actions. It's a much more supportive role when we coach employees. And I don't think managers, that we do this enough. I don't feel like many managers are looking at themselves as coaches. Maybe they're looking at themselves more as a disciplinary role or leader. But this is going to happen before discipline, before corrective action. We need to start noticing if employees are underperforming. We want to coach them to see if we can correct the problem. Maybe they need additional tools. Do they need additional trainings? What can we do? Because now you're protecting the company from any shortcomings that the employee may have. I can't tell you enough how many times the perspective of the employee is, well, I just didn't get trained enough, or I didn't get the proper tools, or even I didn't know I was supposed to do that and now I'm being fired. So again, that plays into the employee's rights as well. So a coach is going to help them determine that before we get there. The coaching session is going to be an open dialogue, and it's going to make the employer and the employee see both sides of the story. So now we're seeing the perspective and they are seeing ours, and you want to document these coaching session. That's going to help you because the next time, and it could literally be the next day, the employee does something wrong, you can use that coaching session that you've documented. That's going to be your supporting evidence that maybe now we need to go to the next step and write them up. It's very effective if everything is done properly, and it can actually help the employee improve. And now we're in a better place with the employee. This is the real world. So we all know sometimes we have those employees who are unwilling or maybe unable to improve. Mostly they are probably unwilling, and that's a big problem and a big concern. So if you have that problem employee who is unwilling to improve or unwilling to hear you out, documentation is definitely going to be critical. It's going to be your sword and it's going to be your shield. It shows that the employee was made aware of their job performance. You made it very clear, and again, it's not enough to tell them verbally. When you are in a court of law and they're not going to know that you verbally told them, again, it didn't happen. If it's not in writing, it didn't happen. Documentation is going to be very critical. It's going to show that the employee knew how to do the job. Um, you know, we've told you this in the meeting. We gave you the opportunity to say, I didn't know how to do this part of my job. We gave them a chance to say, can you please train me? We gave them that opportunity. So it will help you show that the employee failed to meet a reasonable standard of performance. And so finally, it helps to show that the employer used good faith and fair dealing. We weren't just out there to get them. We really did our part in trying to help them improve. We gave them the opportunity, we gave them a chance. And, sometimes right from the onset, maybe within 30, 60 days of hiring someone new, we know right off the bat that maybe that employee is not going to work out. Don't wait. Start the process of coaching, documenting, disciplining. You want to be sure that you can get them out quickly. And again, the documentation is going to help you when you are doing this in good faith, fair dealing. And again, it puts the ball back in their court. All right, so let's take a moment to look at a hypothetical, a scenario. This is actually a real case, and it was a very expensive case for an employer. So here we go. So Carol was a 61-year-old diet technician. She received positive performance reviews for 20 years. Then a new supervisor was hired. So think about it. She started when she was 41, now she's 61, and has had great positive reviews. And now we have a new supervisor. Her new supervisor stated Carol was making mistakes in preparing menus for patients, and then said Carol was no longer competent and could either accept another position, take a severance package, or be discharged. Well, the employee sued the company for age discrimination, and she won her case. Yep, she won, and she won really big, actually. So, what is the problem here? What are we seeing out there? So, if you want to take a minute to place it in the chat, what the concern is that we're seeing here, why she may have won. So let me know your feedback. Give us some of that in the chat box if you're able to. So I think what we're seeing here is a case of a new supervisor, and I think we've all been in certain positions like that, whether it be you personally or maybe you've observed that. So let's see, I think there's a couple thoughts here. So yeah, no prior documentation, that's correct. Performance reviews were positive for 20 years prior to new supervisor. Yep, we don't have any history. So why now, right? There's no supporting documents to support the new manager's coaching, etc. Absolutely. Yep. Again, it's going to be very hard because this is all we have. These are just the facts that we were presented with. And this is what's going to an outside agency. Again, it could be that Carol was making a lot of mistakes. They just went undocumented. It could be that the supervisor she had before, maybe they just didn't really care enough to document any of it. They didn't write anything down, and the new supervisor sees that, and well, now they're trying to improve that, right? But again, no coaching was given in 20 years. I mean, that's really hard to believe. She, again, maybe either had a supervisor that was lazy and didn't want to do anything, or why after 20 years did we not try to coach her and train her? Is something going on with Carol? Is she okay? I mean, so many questions, right? We don't have enough here. But again, this is a real case. So just so you know, they did look at this very factually. And it turns out that she was making errors, but they were allowed to make errors. They were allowed a metric of like 5% error rate. And it was found that Carol actually was below the allowed error rate. She was at about 2% of the error rate. Again, they were allowed to make those mistakes up to 5%. Carol was making mistakes. That's true. But when you look at the requirements, she wasn't making mistakes to the extent where it would warrant this type of conversation. Um, and it may appear now that they really wanted to push her out, and that's why she won. So, again, you want to make sure that we are being factual when we're documenting and know your policy. Because if they would have known that employees were allowed an error rate, this would not have been a problem. And that's why Carol won. So know your policy, know what the requirements of the job are, so that then you're able to proceed in the right direction. So let's just look at this from another perspective. Let's just say Carol really was messing up. She was making mistakes. I mean, preparing menus for patient is very critical. She's a diet technician. She can harm someone's health. So maybe we need to have longer conversations with Carol about what is going on. Maybe she did need more coaching or training. Maybe her workload was too high. So reevaluating her workload, looking at those facts. And as an employer, you really want to look at everything even if Carol is wrong, you have to protect the company and minimize the risk by putting in these barriers. Again, in good faith, we do want to lower the standards of mistakes. Is there a better process that maybe would allow her to make less mistakes? You want to find a way, right, to really connect with Carol and figure out what was actually happening, why these mistakes were happening. Because again, in 20 years, she had nothing in her file. So it's not going to go over very well for the company, even if Carol was making egregious mistakes. All right, so let's take a look at another example. And this one, most of you are probably very familiar with its attendance issues. So now we're looking at your employee, Holly. Holly has been late for her shift multiple times this month. 2 weeks ago, she was 10 minutes late. Today, she was 15 minutes late. Um, a lot of employers at this point, we might say, well, whatever, it's all right. She was just 10 minutes late. Okay, now she's late 15. And we're really not tracking this. But we do need to be tracking this because we need to be thinking ahead before it becomes a pattern. We need to correct it now. So this is where coaching comes in. Hey, Holly, we noticed the last couple of weeks you've been late, and there have been a few days where you've been very late. Get her side of the story. We want to know. And then state the policy. Your position is critical. We need you to be here on time. State the expectation. The next step in the disciplinary process based on our policy. I really need you to correct this because if it's not corrected, it can lead to discipline. But I know you can do better than that. And you want to offer the appropriate help. If you need anything from us, please let us know. Then document that issue, that you gave her that friendly reminder, that you've had that conversation with her and documented it. Well, it continues. Holly has done it again. Now she's been late for her shift for the third time this month. And again, you've coached her 2 weeks ago. She was 10 minutes late, then 15 minutes late, and now she's 20 minutes late. So what are we going to do? Well, sounds like it could be time for a warning. So we're going to summarize what has occurred. You want to write down the number of minutes she's been late, and then again, the specifics on dates. Now, this is just an example. You'll want to look at your attendance policy because your attendance policy is going to dictate how you write this warning. It may be based on your policy that a warning is not warranted yet. Maybe it's just another discussion. So make sure that based on your policy, you're going to summarize what occurred, give her clear instructions regarding the performance or the attendance. For example, no more punctuality issues this month. And then make sure that you state the next step, additional disciplinary action up to and including termination. That terminology should be on everything. So, you have it up here on the screen and it's on your slide deck. So make sure that you have this terminology and everything as you're working through these disciplinary actions. And also on your verbal. So just make sure that you're always reiterating that statement. It's going to save us and help us in the future. And then lastly, you want to encourage them, but do remind them about accountability. It's up to them to improve. Again, the ball is in their court. So what happens if an employee refuses to sign or they are in disagreement? They don't want to sign it. Well, you let them know that the warning still stands. You're going to say the warning still stands and you're going to be held accountable for the content of it. Give them a copy. If they refuse to take a copy, just let them know. Again, they are responsible for the content and you would really like for them to take it, but there will be a copy placed in their file if they want to reference back. And again, the warning still stands. You, the supervisor, you're going to sign it, you're going to date it, and then you're going to write employee refused to sign. Again, let them know that there is a copy available at any time and remind them that they are still responsible for the content and it still stands. So just because they're refusing to sign, it does not go away. A lot of times, another option that employers will do during these conversations is they'll allow employees to write a rebuttal. That's not required, but some employers like to do that as a best practice. It helps the employee feel heard, and then it gives them an opportunity to tell their side of the story. Again, this is not required. You can or cannot do that. It's up to the company. But some employers find it helpful, especially if there's an issue or concern of bigger findings. For example, if they disclose something that maybe is of discriminatory or harassment, something relevant to that. So if you do offer the employees that rebuttal and they do put that in writing, again, you might have to do some follow-up, further investigation. So if you're going to do that, just be prepared to further investigate those issues as well. So let's keep going with Holly because she's done it again. And now she's late for the fourth time. Again, 2 weeks ago, she was late 10 minutes. Last week, she was late 15 minutes. 3 days ago, she was 20 minutes late. And today, she is 12 minutes late. So she's really done it. She's really gotten that warning now. So now the next option maybe is to write her up. It can be a final written warning. You can even suspend her if your policy allows it. You can continue to count this occurrence, or you can even terminate. Whatever you decide, base it on your policy. And remember to be consistent. And by the way, this is a good stopping point for a disclaimer. If Holly were to be using her sick time, that time is protected from all of these tardies, and we would not be able to touch her. We can't be having those conversations like we're having now because sick leave is protected. But in this case, we're assuming that Holly has exhausted all of her sick leave and that she's continued to be late, which is unprotected time. So maybe we are at that point when we need to terminate. So now we're going to ensure that that the termination process is handled professionally, fairly, and in compliance. So we are going to talk about that next. We call this next section Fire Fast because there's really not a lot to say when we've made that decision already. There are some best practices, so you don't want to go through the end of the employment cycle fast, but the meeting is going to be fast. The process should be thought out and methodical. But again, once you've made that decision, then, we want to move quickly. So here's what we mean by fire fast. So let's look at this example. Lately, Jane has been insubordinate and is instigating arguments with coworkers. Jane's supervisor, David, decided it was time to terminate Jane. David spoke with HR about the decision on Monday, and the company decided it should terminate Jane on Friday. Now we're letting her go on Friday because we need coverage. And we just really need Jane to continue working. Or maybe there's a big project we need Jane to finish. So we're just going to wait until Friday. And that happens often, right? But like I said, it's best to do it now. We want to fire fast, but a lot of the times we need that body in that chair until Friday. And so that's what happened here. And unfortunately, David only spoke with HR in person, and there is no paper trail regarding his decision to terminate Jane. Well, just as we expected, on Wednesday, Jane told HR that she needed to take a leave due to a medical condition, a disability. And again, up until now, the company has never disciplined Jane in writing, and in her most recent performance review, all were positive notes. So scary situation here, right? And again, this is why fire fast is important. Once that decision has been made, we need to move on it. Things like this happen in the real world all the time, and these situations tend to escalate quickly. So what are we going to do? Because Jane's performance issues went undocumented, if we let her go now, the company may appear retaliatory because now she's requested that leave, right? So this is why the fire fast and documenting the termination decision is important. Had you spelled it out, you've had your coaching, you had your discipline, you've had your flow of building up your conversations with her, and you were ready to terminate on Friday, and you had all that documentation lined up before she asked for the leave, you might be in a better position. But this does not mean you need to rush through the process. Go through the required paperwork. You just want to make sure that you get the timeline right. So, what can we do now, right? What is it that we're going to do now? So, if a problem employee comes to you and says, well, now I need to leave. Now I'm part of a protected class. Um, in this case, a disability, or maybe they're eligible for leave, such as family medical leave, and you're on the cusp of a termination decision. Well, this is one of those moments where we're going to say you need to consult with legal before you terminate that employee. Every situation is going to be different. They are going to ask for details, for the specifics. They're going to evaluate how many other employees may be under the same situation. There's going to be a lot of questions asked during that consultation time. But some reasonable options that you can consider if you really can't keep Jane, or maybe it's Holly, you really can't hold on to that problem employee. You could, again, now start the documentation, but wait, just wait because, Jane will mess up again. And then we can get her then when we're not at the cusp of her taking a leave. Or you can also consider executing a severance agreement and a release of legal claims. So what that does is, we say we just can't have her here. It's affecting morale. It's impacting us negatively. So instead, we give them a severance, some money in exchange for release of legal claims. And if you are going to move in that direction, please consult with legal before you move forward with those decisions. So let's go through the 3 steps to the lawful termination. So number 1, we want to state the lawful reason. What is the reason? Make sure that the reason for termination is not going to violate the law. Uh, know your protected categories. These should be outlined in your harassment policy if you need to refresh on what they are. And there are a lot in California, so make sure you're aware of those and the growing list here in California. Number 2, separation type. We're going to we're going to determine the type of termination, and we're going to walk through that in more detail in the next slide. So what is the proper paperwork? We're going to conduct the final meeting. We want to make sure we're prepared for that, have your termination checklist, all of your documents, everything ready to go. So I'm sure you've heard this phrase a lot. We are an at-will state, so why can't we just fire them? Well, this is why. So the default is this: the employment relationship is at will and can be terminated by either the employee or employer with or without cause or advance notice. So we feel like, hey, we're protected, right? However, we cannot fire someone in violation of public policy. For example, maybe they filed a complaint, they're a whistleblower, they're based on a protected class. And that's probably what the employee will say, right? If we don't give them a reason, they will find one, or their attorney is going to help them phrase that. And that's why we need to be prepared. We need to think about everything that surrounds this employee before we decide to terminate. So even though that relationship may be at will, again, it's important to document a short reason or explanation for the termination. That way you can demonstrate that it was legitimate. All right, so let's go back to our steps. Step 1, make sure the termination is lawful. So here's some common lawful reasons for termination. Again, violation of employer policies. Make sure your handbook is up to date. Make sure you know your policies and you understand the different consequences for violating those. Poor work performance. Make sure you're having those coaching sessions, that you're continuously having that open door and communication with the employees. Maybe it's a reduction in force. We're unable to continue the doors open, so now it's a layoff. Or it can be something else regarding dishonesty, disloyalty, or maybe a conflict of interest. Again, there's no legally required 3 strikes you're out rule. That's an antiquated rule and it's not legally required. It's nowhere in the California Labor Law Code, so you don't need to follow that rule. And if we know from the get-go that this person is not going to work out, we need to coach them. We need to train them. We need to document. And if needed, we need to terminate. If there's maybe an egregious reason to terminate, you might just jump straight into that. Don't use the term probationary period. This can box you in. If you do, make sure that it does not alter your at-will statement, that when an employee might say to you, well, you gave me a 90-day probationary period, but you're letting me go before then. Again, make sure that the probationary period does not challenge the at-will statement. Some companies have transformed that to an introductory period. Whatever you choose to move forward with, just make sure that it won't challenge that at-will statement. And same thing with progressive discipline. If an employee fights or has misconduct, you don't want to box yourself in to say, well, shouldn't I get a written warning before termination? Well, no, if you're fighting, you're out of here. You don't want to box yourself in having to go through a progressive discipline. Um, Make sure that you're not subject to a collective bargaining agreement or MOU or the public agreement policies. Other rules may apply in those situations. But again, if I haven't said any enough, we're going to talk about documentation one last time, because if it's not written, it didn't happen. And if an event is worth remembering, it's worth writing down. So the importance of documentation when it comes to a poor work performer is going to be different than when you're violating the company policy. If it's a poor work performer, then we're creating awareness. We're saying, well, now that you have knowledge, if you fail to continue to perform, here's the consequences. So that's a poor performer documentation. And when we're documenting for violating company policy, we have an established policy. Again, the employee knew in advance, maybe they received their handbook during orientation. They were warned about these different policies, and you told them that if they violated those policies, there would be consequences. They were given an opportunity to improve before being fired. So when we are documenting, spell those things out. What is the policy that was violated, and what were those consequences? This is going to be evidence as you move into your next step. So let's look at step 2, the type of separation. There's different types of separation from a company. It's important to know that because we need to check it off in the termination paperwork. One of those forms that you're going to have to complete is called the change in relationship form. And this is where we're telling the EDD, the unemployment office, of why the relationship has changed. Was it because of resignation? Maybe, the employee gave you notice. Is it refusal to accept available work? Hey, I have work, but they are refusing to do it. Is it job abandonment? For that reason, you'll want to check your policy on what is considered job abandonment. The state doesn't have any kind of legal requirement of how long you have to document before it's job abandonment. That's strictly based on your policy, whether it's 1 day, 2 days, 3 days, that's up to each company policy. So again, make sure that you know what your policy is and how to apply that. And then was it maybe a termination, a discharge, layoff? Those are other ways that the relationship will change. And lastly, who is the moving party? You want to be clear. Is it a resignation where the employee is deciding, or is there a termination or maybe a discharge? So let's review step 3, how to conduct the final meeting. We don't want to say anything in public because we don't want to embarrass or humiliate the employee. That could possibly cause them to file a charge against you. You don't want to send mixed messages. It's a difficult conversation, and we might be tempted to say something like, well, I'm sure you'll find another job soon. Well, then the employee's probably thinking, well, why can't I just have this job, right? So don't send mixed messages. You want to be empathetic, but don't say the wrong things. And don't tell the employee how they should feel. For example, well, you'll feel better tomorrow. And don't act guilty or seek sympathy like this is harder for me than it is on you. You don't want to do that. If it were up to me, I wouldn't have fired you. Those are very dangerous words. As an agent of the company and as a manager, as a supervisor, as an HR person who's doing the termination meeting, you are the agent of the company and you are representing the company. You are the company, and saying something like that can be very dangerous, and the employee might get the wrong message. So, what is the right way to fire? Again, we want to make sure we're being very factual. We want to make sure that we're documenting and that we are professional. So, here's your to-do list. You're going to schedule a meeting in private. Employees should be paid for that meeting time. You're going to say something like, we need to discuss some concerns or issues today at 2 o'clock. Again, don't forget that's compensable time. So if they don't work their full shift, if you really are calling them in just to terminate, then you're going to pay them for half their scheduled shift, whatever they were supposed to work. That's the reporting time pay, from at least 2 hours, no more than 4, depending on how long they were scheduled. So just know their schedule before you call them in. You want to be honest and professional. You want to be polite. You'll say something like, I have some information I need to give you. You want to be very brief and specific. Today is your last day of work, and don't delay. The meeting should be 10 minutes or less, and then you review the final paperwork. And hopefully it's not a surprise because you've done your coaching, you've done your discipline, you've done all your documentation, um, and they know they didn't do their part. The ball was on their court and they didn't do their part. So the importance of firing someone correctly is most employees that are treated with dignity and respect, they will consider suing an employer 3% of the time and actually only sue 1% of the time. On the other hand, though, employees that are not treated with dignity and respect, they do consider suing their employees 71% of the time and actually sue 19% of the time. So they might not necessarily go through with it, but it's still slightly higher than 1% when you're looking at 19% of the time. So it's definitely in how you say it. That meeting is very important. You want to be respectful. You want to give them the dignity of, releasing them professionally. And then again, make sure that you're prepared with all your paperwork. Through CEA, we do have a termination checklist that has all of these different forms embedded. So you're able to download that as one of our forms on our website. These are required forms. You want to have the notice to employee as to change in relationship. That's how we're notifying EDD of the change. The EDD is the actual pamphlet that notifies employees of their unemployment rights. You can either download these online, or you can go directly to the EDD and request some brochures, and those are free, so they can mail those to you. The notice of health insurance, the HIP notice, this is different than COBRA. This is the California Medical Exchange Notice, and this is for all employees. And then COBRA forms, that's if applicable. You'll want to contact the carrier and see if those employees are eligible, and they can walk you through COBRA. And then the final paycheck with all the wages, the bonuses earned to date, all accrued vacation. So we're going to discuss that a little bit more here. Some of the final paycheck rules. Can an employee withhold a final paycheck? The answer is no. You can never withhold a final check for any reason. Let's just say one employee still has their company property, and we're going to hold their check until they bring it back. Absolutely not. You can never withhold a final check for any reason. Does an employer have to pay commissions and expense reimbursements on final checks? Um, these are allowed to be paid at a later time, only if you're unable to actually gather all of those numbers at the time of separation. So that's a little bit of a flex there, just depending on how quickly you can get that information. Can an employer deduct money owed to the company on the final check? The answer is no. You cannot deduct money from a final paycheck. That is actually never allowed in California. So the pay at termination does have to be a live check, also known as a manual check, for that final pay. It does have to be paid at their primary work location. So if they're a remote employee, you will need to overnight that check. If their work location is not where you are, make sure you're driving to their work location to do that meeting. If the employee requested direct deposit, you'll want to have that in writing, and you will need a second direct deposit authorization for that purpose. If you're a member, you can download that form on our website. And then depending on the type of termination, if it's involuntary or if it's a voluntary with notice of 72 hours, then those wages would be due on the employee's last day of employment. Now, if it's a voluntary resignation without notice, then that allows you 72 hours after the notice is given to have that final check. And then again, the special rule for commission and expense reports, if you're not able to gather all the numbers at the time of separation, those can be paid at a later time. So here's an example of a wage statement. You'll want to make sure all these different elements are included. So again, you have this here on the screen. Feel free to take a picture or you have it in your slide deck. You want to go through each of these sections and make sure that the final wage statement and all of your wage statements actually contain all these different elements so that it could be compliant. So just do a self audit, compare your pay stub to this example here, and then just make sure that all these requirements are actually on the pay stubs for all employees at all times. All right, so there are some penalties. Employees can file a claim with the DLSC, the Division of Labor Standards Enforcement, for any unpaid wages, and those go back 3 years. There are waiting time penalties. Those are up to 30 days wages. And this is when you don't pay that final check currently, or maybe you're missing something and now the employee is owed waiting time penalties. And that's 1 day of the employee's wage times however many days you missed, and then it caps at 30. Interest does add up, and the employees has up to 4 years to file for unclaimed wages from the date the wages were earned. And again, those penalties, if you fail to pay the minimum wage, there's 100 for each pay period. For each employee that was underpaid, and then $250 if there's any subsequent similar violations that happen. And so what if we do terminate someone? How do we share the news? How should coworkers be informed? And again, you want to be professional and very discreet. When you are telling coworkers, you want to let them know who is the individual that's no longer part of the company and how or if they will be impacted. Maybe there's some duties that are going to be shifted, some responsibilities that are now needing to be shared. Maybe you're going to hire a replacement, so you'll want to talk about that and what's going to happen to them, to your team. You don't want to leave them in the dark. You're not going to discuss details with them. We can't do that. But again, you just want to give them some peace of mind of the plan that the company has in order to move forward now without this employee. So some CEA words of wisdoms here. You want to be prepared from the time of hire to fire and throughout the employment cycle. Make the best out of a bad situation. You want to make lemonade out of lemons and end things on the most positive note possible. And we are at the wrap up. So let's develop and maintain strong documentation throughout the employment cycle. Make sure that you can tell that story. Coach your employees. Those are really critical. Just simple conversations, and make sure that you are documenting those conversations as well. Keep a log, keep your notes, have them in writing, and make sure that you're thinking about the consequences. You want to discharge employees with respect and follow those best practices that are going to keep you out of trouble, such as being consistent, knowing your policies, and make sure that the final paychecks are accurate. That is very critical. Again, those penalties do add up. So remember, you do have a hotline in case you have additional questions. We are at the end of this presentation, so I'm going to pass it back to Stephanie here.
Thank you so much, Joanna. And just a reminder, everybody, hello Eli, he's still in the Q&A box, so go ahead and send in any last minute questions you have. He will keep on answering as long as I keep on with this housekeeping details afterwards, so I will talk as long as I can to make sure your questions get answered. Um, just kidding, we'll end soon, I promise. So thank you, Joanna, for putting that hotline board up here. Please make sure you write that number down. Give us a call anytime, Monday through Friday, 8 to 5. We have our HR subject matter experts available to answer your questions. All right, and some of you have been asking about the HRCI and SHRM codes. We do have those available. Your HRCI code is 680471, and your SHRM code is 24-ZV6YV. And again, that's if you're looking for continuing education credits through HRCI or SHRM. And as promised, the survey at the very end of this webinar. Just snap a quick photo of that QR code. It won't take you more than a minute to complete. And we would love to get your feedback, what you loved about this presentation, what you would love to see next time, any topics you would like to see. We want to hear it all. So please snap that photo, tell us your thoughts, and let us know if you have any other questions through the hotline. We'll be there waiting for you. This recording will be available on the Ventura County YouTube channel soon, so keep an eye out for that if you would like to rewatch anything. Thank you, everybody. Have a great day.